And we'll start this first hour giving you an overview of Title IX under the federal regulatory scheme and what it requires so you have context for kind of the life cycle, if you will, of a Title IX sexual harassment claim. And that second plenary session will go beyond Title IX, the federal regulations, to discuss power-based violence, the new Louisiana legislative requirements, and issues of campus culture. So as we start with the substantive presentation, Title IX itself is really simple. It is only 37 words long, but it covers everything that we do. No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any education program or activity receiving federal financial assistance. We've got the statutory cite there for you. Throughout this presentation, we've included citations both to the board's policies as well as federal regulations where applicable, so that you can always go back and read the source material for yourself. It's not just our opinions here. For the most part, we try to give quotes or paraphrase, but we want to provide you the citation so you can go back and make sure that what we're saying is right, and to try to take more time for yourself to internalize these lessons as well. So these 37 words in their simplicity, what do they truly stand for? Well, we'll pick this apart in a couple of ways. It pertains to any person in the United States who's participating in or reaping the benefits under any educational program or activity. So this is persons with or without disabilities, persons from the US, or those who are from other countries who are here taking advantage of educational opportunities in the United States. It pertains to LGBTQ issues, whether you're straight, gay, lesbian, bisexual, transgender. It applies regardless of education status within our educational communities, part-time students, full-time students, employees. If it is a matter of sexual misconduct, the Title IX federal regulations pertain to the conduct and provide certain, in some instances, strict requirements as to what we need to do to address and adjudicate potentially what that conduct is. Title IX applies, you'll see the word recipients used in a lot of the quotes that we have. Recipients refers to the schools, the recipients of federal funding. And obviously, the Louisiana Board of Regents institutions receive a ton of federal dollars, whether it's student financial aid or otherwise. And so what it means is that when we're talking about recipients, that means that each of our member institutions is required as a recipient of federal funds to comply with Title IX. There are some severe consequences for noncompliance. Of course, ultimately, we're talking about the possibility of loss of federal funding, but the investigative steps that may come along with that, whether it's a state investigation or a federal investigation, they can be lengthy. Frankly, sometimes they can be curative. They can help you to understand potentially some things that weren't done right the first time. But setting aside that, it's really also important for us to focus in on providing a safe education environment for any alleged victim before the adjudication has played through. It's also very important, focusing on the students or the other employees or other persons who are involved, that we also move through our processes fairly, seeking truth, and provide due process for the accused. Ultimately, we're looking at the potential for loss of, say, evidence if we don't do this correctly. If we don't do this in a timely fashion, memories fade, documents are lost. It's important that we move through this expeditiously, these processes expeditiously, so that we can avoid not just the negative impact on our campus itself, our institutions, but also the broader campus community and those individuals who at a personal level are most directly affected. So our overarching goal today is to start, I'll say narrowly, but it's also the regulatory scheme provided by the federal government last May. The institution date was August 14th of 2020. So we'll start with the Title IX regulations. We'll move through the BOR's uniform policy, and we'll also, over the course of today and tomorrow, talk about a number of best practices that are applicable to these policies and procedures that we'll be discussing. So again, some of the basic tenets. We want to provide fundamental fairness to both sides. We want to provide due process so that our processes are credible, so that we find the truth, that we do not allow biases or perceptions of biases to impact not just what we do, but also the perception of what we do. We want to be forward-thinking and upfront with our approaches to maximize the credibility of the process as well as the results. Supportive measures are a huge aspect of what we do under the federal regulatory scheme. It actually precedes the adjudicative and investigative processes that have received more attention. Supportive measures come first. We must help our students, our employees, our community members where they are. Supportive measures can apply to a complainant, of course. They can also apply to third parties. They can also apply to respondents. Each of these individuals may be going through their own processes, potentially their own traumas, depending on what the situation may be. And it is important for our institutions to provide supportive measures to assist our students and our employees and other community members to overcome the effects of sex-based and power-based violence. We're also going to spend some time basically giving you the overview. What does this all look like? We know that there are procedures. So generally it's going to come in the form of a report. A report may or may not become a complaint. It may or may not become formalized like that. Either way, we're going to want to try to investigate and figure out what happened, seek that truth. If we have a complaint, there's going to be a certain adjudicative process, and what that process is may vary depending on the circumstances. We're going to have certain things that are necessarily covered by the federal regulatory scheme, and then there are other areas where we have more discretion. Ultimately, any adjudication should also have an appeal process available to lead to finality, but also just to potentially correct if there was an error, whether procedurally or substantively. Throughout this lifespan, we're going to talk about a number of potential exit ramps. And again, depending on if it's a report, it may have an earlier exit ramp where the Title IX coordinator may be able to address it differently. Students can always opt out of this process, or employees or other community members. And ultimately, we also try to provide for some informal resolution approaches that may provide an off-ramp from the formality, at least of the federal regulatory scheme. But of course, we're here to talk about power-based violence. That is the state statute, that is the term used, and it's important that we understand how all-encompassing that is. Despite the title, the term violence is not limited to colloquial violence, meaning physical violence. It encompasses a significant amount of conduct, such as verbal harassment, such as stalking, which may not have a physical component, but the fear of a physical component. Sexual exploitation may not technically be thought of as physical violence, but this concept of power-based violence does include verbal harassment, and really it comes down to any form of interpersonal violence or conduct that is intended to control or intimidate another person through the assertion of power over that person. And this is a list, and you have the citation at the bottom to the uniform policy that embodies these numerous examples of what power-based violence may be. Now, power-based violence is a broad term. It is not necessarily covered under the Title IX grievance procedure that is federally dictated. So we're going to be looking at a narrower set of conduct as we move into the discussion of the federal regulatory scheme, but we absolutely want to make sure that you understand the concept behind power-based violence and the importance of preventing, addressing, and remedying power-based violence when it occurs in connection with our campus communities. And of course, we're talking about sexual activity across a lot of these examples. Human beings, other animals engage in sex. They can consent to sex. What we're talking about here is non-consensual sexual activity. Consent to engage in sexual activity must exist from beginning to end in each instance of sexual activity. And ultimately, what we're doing through these processes of investigation and ultimately adjudication is to determine whether or not consent occurred. Consent must occur for the sexual activity to be permissible in our communities. There are a number of definitions here. Again, this is straight out of the BOR's uniform policy. But consent, just a couple of examples to pull them out here from the bullet points. It must be demonstrated through mutually understandable words and or actions that clearly indicate a willingness to engage in specific sexual activity. Silence does not demonstrate consent if it is silence alone. You can't have acquiescence. You must consent in some sort of affirmative way, such as through words, of course, but also through actions. Consent must be knowing and voluntary. Consent cannot be given if the person is incapacitated. And we'll talk about that in just a second. But also it's important to highlight here that consent to engage in sexual activity may be withdrawn at any time. So again, we will refer you to the BOR's policy for the for you to review the details at another time. We do have a lot of ground to cover, so we want to make sure to keep moving through quickly here. Incapacitation is a circumstance in which consent cannot be given. And incapacitation, ultimately, when we're doing adjudicative processes, incapacitation is oftentimes can be a very important part of the process. Measuring whether or not, let's say, students who engaged in drunken sex, did that cross over to the point where they lost the ability, where they became manifestly unable to make a knowing and deliberate choice to engage in sexual activity. That line to be crossed of incapacitation is a very important line to keep in mind as we measure whether consent was given and whether consent could have been given. One other important concept, both in the federal regulatory scheme as well as under the BOR's policy and Louisiana law, is retaliation. It's expressly prohibited both under the uniform policy as well as the federal regulations. This includes any time when intimidation or harassment or threats or other adverse action may come into play. So of course we have First Amendment rights. We want students and employees and other community members to be able to convey their story, certainly, to speak their truth. But there is a time when that line is crossed into intimidation or harassment or threats. And retaliation against any party or any witness to a sexual misconduct proceeding cannot be retaliated against. And lastly, as we're giving an overview here, we just wanted to give you a couple of terms and people to keep in mind. So the complainant is the first person, the first party who has been impacted by power-based violence or sexual misconduct of some form. We'll talk later about mandatory reporting or responsible employees. We encourage all members of our campus community to report power-based violence. If someone reports, but it did not actually happen to them themselves, they are what's called a third-party reporter. A complainant is the person to whom it occurred or allegedly occurred. And it's important for us to understand that complainants have certain rights under the BOR's policies. Third-party reporters are crucial to our processes, but they don't have the same rights. They are not complainants just by virtue of making a report. The respondent is the accused, the person who has been alleged to have conducted some sort of power-based violent conduct or act. So that's definitional. We also have who are our campus, who sees this process through on our campuses. So we're looking primarily at Title IX coordinators, investigators, and decision makers. Those are three separate and distinct components for complaints. The title, and these really are self-explanatory titles. The Title IX coordinator coordinates all aspects of the proceeding, from intake through the adjudication, post-adjudication, checking on the students or the employees, following up with respect to supportive measures. The coordinator coordinates throughout the entirety of the process and afterwards. The investigator investigates. It's a standalone part of the process to seek truth, to find facts, to organize the case, to ultimately turn it over to the decision maker to make a decision. These are three distinct and independent people in our processes, at least in regard to complaints. We'll talk later about reports as well. But it's important for you to understand that these are three very, very crucial people or groups of people, and they each have a distinct role to play. We'll have some discussion about advisors and confidential advisors. These are people who will help the students or the employees through the process and ultimately may be involved in the hearing itself. And then, as I mentioned a moment ago, we also have responsible employees or mandated reporters. The concept here is that any member of our campus community should report up, and I believe the words used in the statute are must report up to the Title IX coordinator if they become aware of instances or allegations of power-based violence. So with that kind of introduction and overview, I will turn it over to Lexi.
Thanks, Dan. Hi, everyone. So my name is Lexi. I'm an associate at Nelson Mullins with a robust Title IX practice, and I'm here to talk to you guys today about some of the federal regulations governing Title IX sexual misconduct and the relationship between those regulations and the newly enacted Board of Regents uniform policy on power-based violence. So power-based violence, the subject of the BOR's uniform policy, is a broader term that covers more categories of misconduct than the Title IX regulations definition of sexual harassment. However, when power-based violence, used as an umbrella term, meets the criteria designated by the Department of Education in the 2020 Title IX regulations, it must be addressed under the accompanying Title IX grievance procedure. In that way, the Board of Regents uniform policy can be thought of as sort of an umbrella policy governing larger and more numerous categories of conduct than the accompanying Title IX procedures. Most cases that your institutions at your campuses will be touching base on will be investigated and adjudicated under the Board of Regents uniform policy, and Jeff and Nina will cover that policy and all of its procedures in greater detail later this afternoon as well as tomorrow. However, today we figured we would start from the specific and then move to the general, beginning with a discussion of the Title IX regulations and all of their sort of accompanying requirements. So as Dan mentioned earlier, the U.S. Department of Education promulgated new Title IX regulations in the summer of 2020, and those needed to be enacted by August of 2020 institution-wide. The new regulations touch nearly every aspect of a school's Title IX response. We're going to cover these, some of them in great detail, some of them sort of a mile wide and inch deep over the next couple of days, but we wanted to flag a couple of important key provisions for you. The overarching obligation of an institution's general response to sexual harassment is found on this slide. It's a multifaceted definition. It's a very complicated sentence. We'll parse through it as we go. But there are 3 jurisdictional requirements that we wanted to flag for you right off the bat. That a recipient with actual knowledge, which we'll discuss in a little bit, of sexual harassment, the definition of which we will cover later, in an educational program or activity against a person in the United States has a general obligation or a duty to respond promptly in a manner that is not deliberately indifferent when there is that actual knowledge. So these Title IX regulations are significantly more onerous than regulations of the past, but they're non-discretionary. They're mandatory. The Department of Education has given us a very specific play-by-play rulebook for adjudicating instances of very narrowly defined sexual harassment, and we have no discretion to deviate from those prescribed processes. So although this is a narrow subset of actionable behavior, again, you must comply with the federal grievance process as dictated by the Title IX regulations, if and only if the conduct alleged complies with those narrow terms. So parsing out the portions of that long definition on the previous slide, the alleged sexual harassment must involve conduct that occurred under an education program or activity, and it must be perpetrated against a person located in the United States. So an education program or activity essentially covers all of the operations of our campuses and our institutions. It includes locations, events, circumstances over which your campus exercises substantial control over both the respondent and the circumstances in which that harassment occurs. That includes on-campus conduct, such as conduct that occurs in a classroom, but it also could include conduct that occurs within off-campus school activities, at off-campus private property, managed or overseen by a school-sponsored extracurricular organization or extracurricular activity or an organization like a fraternity or a sorority house. There's also a new geographical limitation. The sexual harassment must have been perpetrated against a person in the United States. This is narrower than prior administrations, but however, it does not mean that institutions have absolutely no recourse with respect to sexual misconduct or other categories of power-based violence that occurs outside of these settings. Those investigations and the adjudications must simply proceed under a different process. You guys have that separate process located in your uniform policy. So definitionally, the Department of Education has defined very narrowly the term sexual harassment. That term no longer carries the colloquial sort of umbrella meaning that we all use in sort of common vernacular. There are 3 categories of misconduct clearly enunciated within those regulations. The first one is referred to as quid pro quo or employee harassment. It's determined by an unwelcomeness standard in which a recipient or an employee of the recipient conditions the provision of an aid, of a benefit, of a service upon an individual's participation in unwelcome sexual conduct. For example, there's power differential between a professor and a student receiving a grade in that professor's class. The next category includes other definitional terms: sexual assault, dating violence, domestic violence, and stalking, as defined in the Clery Act and the Violence Against Women Act. And lastly, there's a catch-all term, a provision requiring that unwelcome conduct be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to an education program or activity. Now, for the misconduct to be within this category, it must meet all of those requirements. It's a relatively high standard, and a lot of student misconduct that institutions have previously adjudicated will no longer fall within this bucket. It likely will not encompass, for example, verbal harassment, but it's important to note that effective denial of access to an educational program or activity is a relatively low bar. For example, being frightened to go to class or to a lab because a respondent is enrolled in that class or lab section effectively denies a complainant of the educational opportunities that they may have had. So schools can build out their codes of conduct to address misconduct that does not fall within one of these three buckets. The Louisiana Board of Regents has done so, again, is found in your uniform power-based violence policy. So we've already talked about these involved parties. We've included the citations. Dan has mentioned again that the complainant is the alleged victim, not necessarily the person who reports or essentially complains of sexual misconduct. So again, the next portion of the long definition from a few slides ago, requiring actual knowledge on the part of a recipient in order to trigger the obligation to respond in a manner that is not deliberately indifferent. Actual knowledge occurs when the Title IX coordinator or any other official who has authority to institute corrective measures acquires knowledge of alleged sexual harassment. Nina and Jeff, again, will discuss Louisiana's mandatory reporter policy, which requires effectively all employees to report knowledge of instances of power-based violence or Title IX sexual harassment up to the Title IX coordinator, which imbues actual knowledge to the school, requires it to act promptly, and binds it to the processes that we'll talk about today. So a recipient, an institution, a campus is deliberately indifferent only if its response to sexual harassment is clearly unreasonable. Clearly unreasonable is a high bar, but again, the regulations provide a very explicitly narrow, detailed process that must be followed. Deviating from these procedures might result in the Department of Education or a federal court finding that an institution's response was clearly unreasonable and could result in some pretty significant penalties. It is not good enough under this new regulatory scheme to simply arrive at the right result. The means and the ends matter to this Department of Education, and the process for arriving at your determination of responsibility really matters. There are a bunch of key roles in the formal grievance process. There's the Title IX coordinator, the investigator, the decision maker, the facilitator of informal resolution processes. All of those people are bound to avoid conflict of interest or bias against complainants, respondents, individual parties, or anybody as a result of their sort of categorization. I'll turn it over to Dan to talk about sort of the nuts and bolts of some of the requirements of these new regulatory schemes.
So having now covered the jurisdictional and definitional requirements for when the federal regulatory scheme applies, it's important to then start, okay, what do we do about it? What does the federal regulatory scheme require? It starts here under 44A with a provision of support. A recipient's response to alleged sexual harassment, as defined here by the regs, must treat complainants and respondents equitably by offering supportive measures to a complainant. The sentence does stop there. It continues on to say, and to provide this process that provides fairness and due process effectively to the respondent. But let's pause on this first part. It starts with the notion of supportive measures. And despite that first sentence, the supportive measures must be provided to the respondent or other parties as well. But let's talk about what supportive measures means. Supportive measures must be non-disciplinary and non-punitive. They must be individualized. they must be provided as appropriate and as reasonably available. This does not, so in other words, this might mean that you have to provide counseling, but you don't necessarily have to pay for the counseling. But to the extent that it is the school that is providing the counseling, you cannot then in turn charge a fee to the complainant or the respondent in order to receive those services that you are providing. What I mean is if you go to an off-campus psychologist or counselor, it's not the school's obligation necessarily to pay for that off-campus or non-campus resource. These measures, these supportive measures, are designed to restore or preserve equal access to the school's education program or activity without unreasonably burdening the other party. So this does mean that if you've got a no contact order situation, we need to separate two students who are currently in the same class or the same lab. While in the past, perhaps we would have always removed the respondent, the accused. Here, there is an obligation under the federal regulatory scheme that we must not unreasonably burden the other party. So there needs to be a certain weighing of who will be removed or inhibited in taking advantage of your educational opportunities more. And so we need to try to provide these non-disciplinary, non-punitive, non-burdensome support measures in order to assist our students and our other campus community members, employees, faculty members, et cetera, to try to help them flourish and succeed within the educational activities that we provide. So your BOR policy, as well as the regulations themselves, provide a number of examples of supportive measures. And of course, we've talked about some of them already: counseling or extensions of academic deadlines or modifications of work or class schedules. It also transcends into campus supportive measures. You may need to increase security or monitoring of certain areas of the campus. You may need to or want to provide campus security escort services. But of course, we are primarily and first and foremost focused on the parties who are impacted by the alleged conduct. So procedurally, how do we go about doing this? The Title IX coordinator, we're getting back to the who, the Title IX coordinator under the regulatory scheme must promptly contact the complainant in order to start discussing the availability of the supportive measures and to gain information about the complainant's wishes with respect to supportive measures. This should be an interactive dialogue. It is not up to the complainant to necessarily request a no contact order or something like that. It should be something that the Title IX coordinator offers. And as we said before, it's something that probably should be expressly delineated within the materials that are provided to the complainant. And in due course will also be provided to the respondent. But in the first instance, when the report comes in and the Title IX coordinator receives the set of allegations, whether in the form of a report or a complaint, Title IX coordinator begins by promptly contacting the complainant to discuss the possibility of supportive measures, to also discuss that supportive measures are available with or without proceeding through the formality of the adjudicative and investigative process, and then also explaining what that formal complaint means and what the process may be as it plays forward. We'll turn now to the grievance process itself. So let's say that a complaint does come in and we move into the grievance process. So this is transcending 106-44 and moving towards 45. What exactly do you need to do through the grievance process after supportive measures have been provided or offered to the complainant and the respondent and potentially other affected parties? Well, once again, going back to that sentence that I said was kind of, we left off with the ellipses before. The recipient's response must treat complainants and respondents equitably, not only by providing those supportive measures as we've been talking about, but also by following a grievance process that complies with 106-45 before the imposition of any disciplinary sanctions. You must go through the process. If this is a situation of definitional and jurisdictional sexual harassment as defined by these regulations, then you must go through this process before imposing disciplinary sanctions against a respondent. I think for the most part, the slide says the same thing. So how does it get initiated? The grievance process is initiated through a formal complaint. This is a document that is filed by the complainant, potentially signed by the Title IX coordinator, but it's really, we hope in the first instance, a decision made by the alleged victim. It is a document filed by the complainant that is alleging sexual harassment as defined through the regulations, as Lexi explained before. So it's quid pro quo, or domestic violence, dating violence, sexual assault, or it is conduct that is so severe, pervasive, and objectively offensive that it effectively denies educational opportunities. If it is that sexual harassment, then if the complainant requests that the recipient of federal funds, the school, investigate those allegations, then we must move forward. That must be in writing, and that is what constitutes a formal complaint to trigger this adjudicative and investigative process under section 106.45. A couple of kind of asterisks on this. At the time of filing a formal complaint, the complainant must be participating in or attempting to participate in the education program or activity of the school. There is a circumstance under which the Title IX coordinator can sign a formal complaint in order to carry out the school's obligation to provide a safe and effective campus community. We'll talk about that in a moment. But in the first instance, we really are hoping that we are following the complainant's wishes to move forward through this process. The facilitation of filing a formal complaint should be easy. It may be filed with the Title IX coordinator in person, by mail, by email. This contact information of how to file a formal complaint must be listed in your official policy and should be readily findable by any, let's say, drunk student who's just been assaulted and at 2 o'clock in the morning. This should be readily available in order to facilitate the easy filings of formal complaints. So we also have circumstances under which a Title IX coordinator may sign a formal complaint, again, to initiate or continue a Title IX formal grievance procedure if necessary in order to fulfill an institution's duty under Title IX to not be deliberately indifferent to actual knowledge of sexual misconduct. In this instance, the Title IX coordinator does not step into the shoes of the complainant. The Title IX coordinator does not acquire the rights of that complainant, but it is in carrying forward the obligations of the school to take prompt action in response to actual knowledge. So this is something that the Biden administration recently issued a Q&A document on, and they explain the rationale behind this. A school has a Title IX obligation to provide all students, not just the complainant, with an educational environment that does not discriminate based on sex. So there may be circumstances under which a Title IX coordinator must step forward, even in the absence of a complainant, in order to sign a formal complaint and then trigger the investigative and ultimately the adjudicative process. So we do absolutely encourage complainants to move forward with the filing of a formal complaint in order to start these processes, but there are a number of off-ramps. We're not here to force students or employees or other campus members to go through the entirety of the process. If a complainant chooses to withdraw their formal complaint at any time, they may do so. If the conduct alleged is definitional and jurisdictional under the regulations, meaning it's that sexual harassment as defined by the federal government, in that circumstance, the withdrawal of the formal complaint concludes the Title IX formal grievance process, and no disciplinary action may be taken against the respondent unless the Title IX coordinator steps forward and decides to sign or file a formal complaint on the school's behalf in order to continue the investigative and adjudicative processes. So that is a permissive dismissal upon the wishes of the complainant, with some discretion for the Title IX coordinator to continue that process if needed. There's mandatory dismissal, though, as well. If the conduct alleged does not fit these jurisdictional and definitional requirements that we've given you in regard to sexual harassment, or it's behavior that has not occurred or alleged to have occurred within the education program or activity of the school, if it doesn't fit the regulations, then the institution must dismiss the formal complaint under this formal process. However, that's when the BOR's uniform policy kicks in. Title IX coordinator will transfer the complaint to the BOR's policy in order to further address the power-based violence that, in this instance, does not fit within the regulatory scheme. There are a couple of other just real quick permissive dismissal sections if the respondent is no longer enrolled in or employed by the institution. At a certain level, the proceeding may become moot at that point because you cannot take action against the respondent. Perhaps you can. with respect to community measures in order to ensure a safe and effective educational environment. So again, it's permissive dismissal if the respondent is no longer enrolled or employed by the institution, but it is a circumstance in which you can consider, or the Title IX coordinator can consider, dismissal. And then there also may be circumstances in which you simply cannot gather sufficient evidence to reach a determination. That would be a circumstance for permissive dismissal as well. As I said before, you must go through the entirety of this adjudicative process before instituting disciplinary measures. However, we recognize that there are certain circumstances in which emergency removal may be appropriate. And that is provided under the regulatory scheme as well. It's under 106.44C. The school must engage in an individualized safety and risk analysis. There must be an immediate threat to the physical health and safety of a student or the community. So if there was a horrendous sexual assault the night before, but it was alleged that it occurred during during a time of drunkenness or potentially incapacitation by the respondent, when that individual wakes up the next morning in a sober capacity, they may no longer pose an immediate threat to the physical health or safety of the individual or the community. We don't know. That is part of the individualized safety and risk analysis that must be conducted. But that is the threshold for emergency removal, that they pose an immediate threat to the physical health or safety of any student or another individual arising from the allegations of sexual harassment. And lastly, under emergency removal, you must provide due process. You must provide a notice and opportunity to challenge that decision. Ultimately, it also must be consistent with the ideals of the ADA and the other federal and statutory protections that are provided to someone who may be removed in such a circumstance. This does primarily pertain to students. So institutions may place non-student employees who are alleged to be respondents on administrative leave during the pendency of a formal grievance process, so long as those employees' rights are respected.
Perfect. So wrapping up some of the overarching requirements of an institution's formal grievance process, retaliation is expressly prohibited under the Title IX regulations, where they are in fact prohibiting retaliation by a school or by any person involved in that process. Retaliation can take many forms, whether it's intimidation, threats, coercion, discrimination. You cannot retaliate against a party for refusing to participate in a formal grievance process. Nor can you use a general code of conduct to circumvent these procedural requirements and abrogate due process. You cannot, for example, charge a respondent with assault as opposed to sexual assault in order to avoid those procedural requirements. The U.S. Department of Education's theme of due process absolutely cannot be abrogated in any scenarios. There are some exceptions to this retaliation provision. For example, students, faculty members, institutional employees exercising their rights to free speech under the First Amendment may not constitute retaliation, and also charging an individual for lying during that process, making a materially false statement in bad faith in the course of a grievance proceeding does not necessarily constitute retaliation. This is a bit of a murky area, but if a retaliatory conduct is verbal in nature, it may fall outside of the definition of retaliation because it may in fact be protected under that First Amendment right to free speech. And then finally, it's an important time here to sort of pump the brakes, make sure that we're emphasizing the importance of adherence to these formal grievance procedures, because the Department of Education has made explicitly clear that a recipient, an institution, a campus's treatment of a complainant or a respondent in response to a formal complaint of sexual harassment may in and of itself constitute sex discrimination under Title IX. So again, this should underscore the importance of adhering to these new formal grievance processes when they apply. When addressing a formal complaint, the school must, as we've said, a couple of times at this point, comply with the Department of Education's Title IX regulations. As we'll talk about in more detail later, that includes in the entire process, from investigation to notice requirements, the new requirement for a live hearing with cross-examination, determinations of responsibility, and appeals. Dan will cover briefly some of these core grievance procedure requirements.
Right, and so the basic requirement is that you must treat complaint, and again, we're quoting here and we're providing the citations to both the BOR Title IX grievance procedure as well as the federal regulatory citation. The school's grievance process must treat complainants and response equitably in providing remedies to a complainant where a determination of responsibility for sexual harassment as defined here has been made against the respondent, and by following a grievance process that complies with this section, which is 106.45, before the imposition of any disciplinary sanctions or other actions that are not supportive measures against the respondent. It requires an objective evaluation of all relevant evidence, both inculpatory and exculpatory evidence, and provide that credibility determinations may not be based on a person's status as a complainant or a respondent or a witness. So to break that down a little bit, we're going to talk about the relevancy of evidence. Inculpatory and exculpatory evidence means that you must understand or at least consider evidence that may help or hurt either party, depending on what the facts may be or the evidence may be. And ultimately, the credibility determination must be made with respect to the evidence that is presented, not merely the person's status in regard to being a complainant or a respondent. We aren't going to make assumptions based on who they are, but rather we will make determinations of credibility based on what they say and what the evidence instructs us to follow. It is provided in both the statute and the BOR's Title IX grievance procedure that the respondent is presumed not responsible until a determination is made at the conclusion of the grievance process. And ultimately, we need to move through this process reasonably promptly. I suggested this at the beginning, but it's also embodied within this particular portion of the basic requirements of the formal grievance process. Under the Obama administration, the 2011 Dear Colleague letter, there was a recommendation that we move through the process, the adjudicative process, within 60 days. There's no longer that type of distinct time frame, but we must move reasonably promptly through it, including the formal process as well as the appeals. But we also must provide for temporary delays in order to provide due process to both parties, fairness, fundamental fairness. If there's good cause, such as the absence of a party or the advisor who must conduct the cross-examination, if a core witness is not available, if there's a concurrent law enforcement activity, this campus can stand down and extend the time frame. But to the extent that we can, we must reasonably promptly move through the basic requirements of the formal grievance process. We must use a uniform standard of evidence. So schools have discretion to choose. You may either use the preponderance of the evidence standard or the clear and convincing evidence standard. But the key here is that you must apply the same standard to all formal complaints. So this Title IX regulatory scheme pertains to both students and employees. So if you have a faculty, tenure revocation process, and that formality provides for a clear and convincing evidence standard, unless you amend that, then that clear and convincing evidence standard must also pertain to your student sexual misconduct or sexual harassment proceedings. The flip side of that is if you choose that you wish to have the preponderance of the evidence applied for sexual harassment cases that are adjudicated, then you must carry that all the way through and apply that same preponderance evidence standard to the tenured faculty member and amend potentially your formal faculty, formal disciplinary process to decrease the standard of evidence to preponderance if that faculty member is accused of sexual harassment as defined here by the federal regulations. Just a couple of other things that are statutorily required. You must describe the range of supportive measures available to the parties. We've talked about that a lot. As we get into the adjudicative side, you may not allow any evidence or questions that would invade a legally recognized privilege. But really where we want to start with the formal grievance process is at the beginning. When we get into the formality of the process, you must provide notice. You must keep the students or employees or other community members informed of what's happening. So upon a receipt of a formal complaint from a complainant, the school must provide the known parties, including the respondent, if known, with written notice of various matters. This includes the allegations. There's no ambush investigation or interview of the respondent, which not very many schools do, but there were allegations that used to happen. So you must provide written notice of the formal complaints allegations. You must provide notice of what this procedure is going to be. You must provide notice that any code of conduct provision that knowingly making false statements or submitting false information is prohibited under your code of conduct. You must provide notice beyond this. And again, you can go back and look at the citations that we've provided, but you must provide notice that the responder is presumed not responsible until a determination is made at the conclusion of the grievance process. You must provide notice that the parties, both parties, are able to have an advisor of their choice to help them through the process and ultimately potentially to conduct cross-examination if we reach a hearing. You must provide notice that both parties may inspect and review evidence. We would refer you to the citations for additional information in terms of how you must communicate and what you must communicate to the parties. Ultimately, you also must describe the range of potentially available disciplinary sanctions and remedies. We will note that this is something that falls to individual campuses under the BOR's grievance procedure. So this is something that you're going to have to think about as you finalize your own campus policies in response to the BOR's overarching documents. And lastly, you must notify the parties involved that they do have the right to appeal and what those procedures and bases are. With that, I'll turn it back over to Lexi.
So now we'll dive in at sort of a high level to some of the nuts and bolts of the actual investigation process. What does that look like on a campus level? So the burden to investigate allegations of narrowly defined sexual harassment is on the institution itself. This is, even though the institution is not a party, you typically hear of the burden of proof being on the plaintiff, or at least a party in a civil suit, or the state or the prosecution in a criminal matter. However, this implication that the burden fall on the institution is consistent with our sort of core tenet of seeking the truth. The burden is in fact placed on us as institutions, as neutral parties. We must complete the investigation in order to seek the truth. That investigation process also must include the opportunity to suggest, provide evidence, whether that's in the form of witnesses, inculpatory or exculpatory evidence, as Dan said, those pieces of evidence that may help or hurt either side's case. And the investigation process may not restrict the party's ability, either party's ability, to discuss that case and gather the evidence as required. In the investigation process, parties are required to be provided with the opportunity to include an advisor of their choice. Institutions cannot limit the choice of or the presence of an advisor during this investigative phase. However, schools can adopt a policy that advisors may only attend proceedings as sort of silent observers, potted plants. There is not at this point any requirement that a party take advantage of this opportunity. Or that an institution provide an advisor to a party who does not have one at this stage. The notice requirements throughout the policy make sense. In order to execute that concept of fundamental fairness, we must effectively communicate the processes, logistics, and expectations to the individuals involved. You must provide to parties whose expectations or whose participation you expect, where they should be, when they should be there, the purpose of them showing up, and sort of what the process looks like moving forward in order to make sure that they're most able to effectively participate. There's also a requirement that during this investigative phase, that the parties be provided an opportunity to review any evidence before that evidence is finalized into an investigative report. You must send that evidence to the parties and to their advisors and give them a period of time, here 10 days, in order to provide feedback on that evidence. The investigator must then consider those responses, if any, before completing that final report. Here, there's an important sort of carve out or caveat. The regulations trump FERPA in this instance, so that institutions and investigators of Title IX sexual harassment can liberally share this evidence and this information between the parties as needed. You don't have to redact this sort of pre-investigative or pre-report investigatory evidence. The investigative report itself must fairly summarize the relevant evidence. Evidence is relevant if it speaks to whether the facts underlying an allegation are more or less likely to be true. It's relevant if it has probative value to make an allegation likelier or not. And at least 10 days before any hearing, the investigator and Title IX coordinator must provide the parties and their advisors with a copy of that investigative report for their review and written response.
So that's a quick overview, again, of the federal regulatory scheme with respect to the investigative phase. Again, this is going to be the exception more than it's going to be the rule in regard to the idea of how prescriptive this is. Most of the cases may not proceed all the way through to the point of hearings where they fit definitionally what sexual harassment is under the federal regulatory scheme, or jurisdictionally that the conduct occurred within an education program or activity within the United States. But when we are going through this process, when it fits definitionally and jurisdictionally, ultimately we move on towards hearings, again, at the discretion of the complainant, who does have the right to withdraw a formal complaint if they wish. But if we do proceed to the hearing phase, post-secondary institutions must provide for a live hearing in order to reach the ultimate decision. I'm starting to carve out, and I think we've been doing it throughout, carve out or differentiate between the BOR's uniform policy and when the federal rules pertain here. So the BOR's uniform policy grants significant discretion to member institutions with respect to resolution proceedings. It does not require any specific adjudicative process under the BOR umbrella policy, such as a hearing board or an adjudicative panel or a single decision maker. They must be a separate individual from the investigator or the Title IX coordinator, but institutions do have discretion outside of this regulatory scheme, meaning the federal regulatory scheme. But when we find ourselves jurisdictionally and definitionally dealing with sexual harassment, you must have a live hearing. We can have, again, it must be an independent decision maker from the investigator and the coordinator, but it can be one or more decision makers. When we get into the hearing itself, the cross-examination must be allowed. Decision makers must permit each party's advisor to ask the other party and any other witnesses all relevant questions and follow-up questions, including those challenging credibility. So Lexi mentioned a moment ago that advisors are not required to be provided during the investigative phase, but once we reach the hearing, the cross-examination can only be conducted by the advisor. Parties are prohibited from directly confronting each other. And so with this advisor requirement, we, the institution, must provide an advisor to carry out this cross-examination obligation. Cross-examination must be direct, it must be oral, it must be done in real time. And as I said, the advisor not only must be appointed, but it must be appointed by the school, provided by the school, without fee or charge to that party. Cross-examination must cover relevant topics. Only relevant cross-examination and other questions may be asked of a party or witness. So that means that your decision makers must be screening for relevancy in real time. And as Lexi mentioned, this is anything that makes it more or less likely that an allegation was true. This relevancy, one of the most important relevancy determinations, really intersects with the rape shield protections that are provided by the BOR's grievance procedure at Section 8C, as well as the underlying federal regulation 106.45. We've provided that. But the rape shield protection provides that questions and evidence about the complainant's sexual predisposition or prior sexual behavior are not relevant. They are per se not relevant unless such questions and evidence about the complainant's prior sexual behavior are offered to prove that someone other than the respondent committed the conduct, or if the questions and evidence concern specific instances of the complainant's prior sexual behavior with respect to the respondent and are offered to prove consent. So circle back to that definition of consent we provided earlier. Consent yesterday to sexual activity does not mean that I consent today to sexual activity. Consent to certain aspects of sexual activity does not mean that I consent to other aspects of sexual activity. So ultimately, as we're looking at this rape shield protection, what relevant questions may be asked about the complainant's prior sexual behavior with respect to the respondent, we must hone in on whether or not it is evidence of consent of this instance, the alleged conduct itself, not proving consent from yesterday. Now, there may be some relevancy to yesterday's consent if it was the way in which the complainant conveyed consent. There are circumstances that may be applicable, but we need to be careful to uphold the rape shield protections that are in place. Okay, so this is like late breaking news. The regulations themselves provide, and in turn our policy, the BOR's Title IX sexual grievance procedures provide that if a party or witness does not submit to cross-examination at a live hearing, then the decision maker must not rely on any statement of that party or witness in reaching a determination regarding responsibility. So this was in the regs. 1 week ago today, a federal court had ruled that this must be stricken as arbitrary and capricious and no longer carries the force of law, at least in regard to the regulatory scheme. Now, schools can still carry it forward. It can still be the rule in regard to our own policymaking. And so as of this moment, this is the term within the BOR's grievance process. But we need to also kind of put an asterisk on this. This may change. It no longer, the regulation itself on this portion no longer carries the force of law. And so the BOR may choose to change this aspect of the policy. If it does change, then the decision maker would have discretion to consider other evidence, regardless of whether or not the party submitted themselves to cross-examination in regard to the evidence provided. We will circle back to one thing that we said before about we don't make assumptions. We don't assume that the respondent must be responsible just because they are accused. We must weigh the evidence itself. Similarly here, the decision maker is prohibited from drawing an inference about the ultimate determination of responsibility, prohibited from drawing an inference based solely on the parties or witnesses' absence or the parties or witnesses' refusal to submit to cross-examination. You cannot make the ultimate determination that they must be responsible because they did not submit to cross-examination. Okay, so a little bit on logistics. This is a much easier provision than it used to be before the pandemic. Virtual hearings are something that must be provided at the request of the parties. These two individuals understandably may not want to be in the same room together. And in that instance, the school must provide for a live hearing to take place with the parties located in separate rooms. The technology must be in place so as to enable the decision maker and the parties to have the full benefit of the testimony, to simultaneously see and hear the party and the witnesses who are answering questions. But they don't necessarily need to be physically present in the same location. Our hearings are recorded. So that may be an audio recording, an audio-visual recording. It may be a transcript of only the words that are spoken, but they must be recorded. And then ultimately, as we turn to the determination of responsibility, once again, the regulations, as well as the BOR's Title IX grievance procedure, provides for a specific manner in which the decision maker must issue written determinations regarding the finding of responsibility and how they got there. So the written determination must include the allegations, the procedural history, the findings of fact, and how those conclusions reached by the decision maker came from those findings of fact, applying the conclusions, conduct, as well as the facts that support the finding. And then, as stated before, and of course, it must not only have the finding, but also any disciplinary sanctions or remedies. And then ultimately notice that there may be an appeal taken from this initial determination of responsibility from the hearing. Whatever that determination of responsibility is, it must be simultaneously published to both parties. And it can potentially carry finality. And it's important that we convey that to the parties. Unless someone appeals, this is the end of the road under these definitional and jurisdictional cases. So of course the appeal is possible, but in the absence of an appeal, this is the final result. Now we're going to come all the way back to our who. The Title IX coordinator ultimately retains responsibility. So they don't make the decision, they don't conduct the investigation for a formal complaint, but the Title IX coordinator is there every step of the way, and ultimately the Title IX coordinator is responsible for the effective implementation of any remedies that are ordered via the hearing and adjudicative process, and potentially even circling back to all the way back to supportive measures. Should we still convey a mutual no contact order between the parties even after the remedy? So the Title IX coordinator never loses jurisdiction. But let's talk about an appeal first.
So moving along the sort of timeline process of an investigation and adjudication of Title IX regulatory sexual harassment, institutions must offer both parties, complainants and respondents, appeals at various stages of this procedural timeline. You can appeal the dismissal of a formal complaint, the dismissal of any allegation contained in that formal complaint, and the parties can appeal the determination regarding responsibility at the conclusion of that investigation and decision-making process. There are several grounds for that appeal. The regulations and the board's final policy provides that campuses may, in their discretion, offer appeals as long as they are equal to both parties on additional bases, but it also does prescribe some mandatory grounds for appeal. For example, a procedural irregularity, again, emphasizing the importance of adhering to the Title IX regulations, procedural and sort of due process requirements. An additional ground if there is the uncovering of new evidence that wasn't available at the time the determination was made, that could affect the outcome of the matter. There is also a materiality threshold accompanying that. Not only does the evidence need to be new, but it also needs to be material. And then finally, hearkening all the way back to one of our overarching concepts, that the Title IX coordinator, the investigator, or the decision maker must be prohibited from a conflict of interest or instigating any bias if an allegation is made that the Title IX coordinator or any other involved party did in fact have that conflict of interest or instigated any sort of bias for or against any party, then the institution must grant the appeal. There are some procedural requirements. For example, an institution must notify the other party in writing when an appeal is filed. You must give both parties a reasonable and equal opportunity to submit written statements in support of or challenging the ultimate outcome. And then you must provide the written decision of the ultimate appeal simultaneously to both parties. Dan mentioned earlier that there are several off-ramps within this Title IX regulatory scheme. One of those, very briefly, is informal resolution, and that provides that at any time prior to the ultimate determination of responsibility, an institution may facilitate an informal resolution process, such as a mediation or an arbitration, or it may take some other form that does not involve a full investigation and adjudication. However, you must provide written notice to the parties before involving them in an informal resolution process. That notice must include the allegations, the requirements of the informal resolution process, again, making sure that parties are well informed and communicating clearly about the expectations of a single process, whether that be the formal or the informal adjudication. You also must provide parties with notice of the fact that at any point they can revert back from an informal resolution process back to the formal process, which would simply pick up from the time at which it was paused. As well as you must provide a notice that any consequences or of any consequences resulting from participation in that informal resolution process. The idea of an informal resolution is meant to empower parties in order to implement such concepts as restorative justice and to potentially avoid some of the heightened emotions and potentially trauma that might be affiliated with a live hearing, especially with that cross-examination requirement. And then finally, last but most certainly not least, there's a explicit record-keeping provision in the Title IX regulations. It might sound boring, it might sound custodial, but it's incredibly important under the new regulations, and it can cause pretty significant issues for your institutions if schools don't comply. For a period of 7 years, which is not an insignificant amount of time, each campus must maintain records of pretty much everything that touches Title IX, sexual misconduct, power-based violence. You must maintain records of each investigation, the determination, the sanctions, and the remedies affiliated therewith, the appeals therefrom, informal resolutions, and training materials like this one. A primary purpose of these is for OCR auditing and investigative purpose, but also in the unfortunate event that an institution finds itself in litigation, these records will also be a likely target of discovery efforts in that private litigation. So you don't want to have to recreate the wheel every time you're responding to discovery or to document requests, and so making sure that organizational frameworks are implemented across each member institution and across each campus will help in the long run. All right, so we have covered an absolute just ton of ground today in a relatively short amount of time. These regs are critically important. They have the force and effect of federal law. They impose significant responsibilities and obligations on each institution, on the employees therein. Our contact information is on this slide. If you have any questions about these new Title IX regulations or the processes required within them, please feel free to let us know. We are absolutely here to help.